YouTube, Natalie here. Welcome back to my channel. Thank you guys for tuning in. This video is a result of a poll that I put on the community page. I asked you guys whether or not you wanted to see a video about what to do if you're pulled over by the police or why you shouldn't speak to the police. You guys overwhelmingly answered that you wanted me to do a video on what to do if you're pulled over by the police. So I thought that I would give you guys a little bit of a legal lesson. Just so you guys know, I'm an attorney, criminal defense attorney, and also give you guys some examples of what you should or should not do when you are pulled over by the police. Okay, guys, so what to do when stopped by the police and what not to do. Under the Fourth Amendment of the U.S. Constitution, you would think that the police need a warrant every time they need to interact with you because the Fourth Amendment says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons and things to be seized. But there are three types of police interaction that allow the police to search or arrest you without a warrant. The first is a mere accosting or consensual encounter. Now, this doesn't necessarily mean that the police can search or arrest you without a warrant, but a lot of the time, a mere accosting or consensual encounter will lead to an arrest or a search based on how you interact with the police. So there's a United States Supreme Court case from 1980 called United States v. Mendenhall. And in that case, the Supreme Court found that police are able to approach and initiate conversations with civilians, and that these consensual conversations do not require any justification. So just like how I can go up to anyone in public and initiate a conversation with them, the Supreme Court has found that the police are able to go up to people and initiate conversations with them. But in real life, people don't realize that when a police officer comes up to you on the street, 9 times out of 10, that is a consensual encounter. I'm not talking about traffic stops. I'm talking about if you're a pedestrian on the street and a police officer just approaches you out of nowhere. If you consent to speaking to that police officer, that can escalate into a search, a detention, or an arrest because you have consented to that interaction, even though most people don't know that they've consented. So how do you know if it is an accosting? Number one, if a police officer comes up to you in public, ask them, why are you being stopped? Or why are they coming up to you? And then ask them if you're free to leave. If the officer says he just wants to talk, that is an accosting or a consensual encounter. If the officer says that you're free to leave, that is also an accosting or a consensual encounter. Now, the officer may have had no reason for why they approached you at all. And if they say, I just want to talk, and you say, I want to leave, and then they say, no, hold on, that has escalated into a detention outside of a mere accosting. So most times the way the law is supposed to work, although we know it doesn't always do that, is that the officer is supposed to say that you're free to leave. And if an officer ever tells you that you're free to leave, this is what you should do. So what should you do when you're accosted? Ask if you're free to leave, and if the officer says you're free to leave, then leave. Searches occur during accostings. So if an officer asks you to search you, it's because he can't. So if an officer just comes up to you out on the street, there are some situations in a traffic stop where an officer may ask to search. And if the officer is asking, may I please search you? And the answer could be yes or no. The answer should always be no. Never give an officer consent to search you or your vehicle. If an officer asks to search you, say no. They may try to persuade you. They may try to make it feel like you'll look better if you just say yes. And a lot of the times my clients, on a personal note, a lot of the times my clients will tell me, well, Miss Natalie, I knew I had something in the car, but I thought that if I just gave him permission to search, he wouldn't want to search because he'd think, Why would somebody give me permission to search the car if I had anything? That type of reverse psychology doesn't work, unfortunately. The way that it really works is that if you give an officer permission to search your vehicle, he's going to search your vehicle. So always say no. And if he has to ask for permission, it's because he can't do it on his own. Number 2, the second type of encounter that can lead to a search or an arrest short of an arrest warrant or a search warrant is reasonable articulable suspicion that criminal activity or a traffic violation is afoot. Where does that authority come from, and what does that mean? The United States Supreme Court, in the case of Terry v. Ohio, a case that is seminal to Fourth Amendment jurisprudence, Fourth Amendment cases that came out in 1968, it found that the Fourth Amendment does prohibit unreasonable searches and seizures. However, that is not violated if the officer has reasonable articulable suspicion that criminal activity is afoot, or RAS. And the officer has a reasonable belief that a person may be armed or dangerous. So what does reasonable articulable suspicion that criminal activity is afoot means? It means that the officer has some type of reason for believing that there may be a crime that is being committed. It does not need to be to a certainty, but it does need to be something that the officer can verbalize out loud when you ask them why they stopped you. For example, you have a taillight out. You turned the wrong way on this road. You went through a red light. You went through a stop sign. That's all reasonable articulable suspicion that either a crime or a traffic violation is afoot. And the cases that came after Terry v. Ohio did find that it doesn't just apply to crimes, it also applies to traffic violations. In the Terry v. Ohio case, that was about people casing outside of a closed business. So the people were walking around the closed business. It was after hours. It was in a neighborhood that was high in crime. And based on that, the officer was able to articulate his suspicion that those people were involved in the potential criminal activity of burglary. And the court found that that was enough suspicion for the officer to be able to detain the person. When you're being stopped for reasonable articulable suspicion that criminal activity is afoot, you are being detained and you are not free to leave. So if you ask the officer, why did you stop me? I thought that you were casing this joint. Am I free to leave? No, you're not. Then you can't leave, okay? Now, in order for a officer to search you after they stopped you for believing that there was reasonable articulable suspicion that criminal activity was afoot, in order for them to search you, they also have to have a reasonable belief that the person may be armed or dangerous. Okay, armed and dangerous, both armed and dangerous. When an officer stops someone for reasonable articulable suspicion that criminal activity is afoot and they believe that the person is armed and dangerous, they have the right to do a pat-down search. Now, what is that reasonable belief as to a person being armed and dangerous? For example, if a person is known to the officer and the officer knows that person to have been arrested or convicted of possessing a gun, that would be reasonable belief that the person can be armed or dangerous. If the person is making furtive movements to their waistband, looking as though they may be concealing a weapon on their waistband, that would be reasonable to believe that the person may be armed and dangerous. If the person is in a high crime area and then they attempt to evade the officer who tries to stop them, say they run away or turn their body away from them, in coordination or in conjunction with them being in a high crime area, it has to be those two things together. The courts have found that that is reasonable belief that the person is armed and dangerous. So those are all examples of the officer having a reasonable belief that the person is armed and dangerous. Now, based on this reasonable belief, that does not give the officer the right to do a full-blown search on the person. So if the officer says, look, I don't like the way that you're moving, I think that you're concealing something in your waistband, or I know that you have prior convictions for handguns, and I'm gonna pat you down for weapons. They cannot do a full-blown search. They can only do a frisk, or a pat down. So the officer has the right to pat down the person for weapons and seize anything under the plain field doctrine. If you're still in the car when the officer reaches this reasonable belief that you could potentially be armed and dangerous and they haven't removed you from the car, they also have the right to search the glove box under what's called the wingspan doctrine. And I'm going to explain this. So what is the plain field doctrine? If the officer does a Terry frisk / pat down and he can only touch the outside of your clothes, meaning he can't go inside your clothes, can't go in your underwear, can't go in your pockets, can only touch the outside of your clothes. But if he touches something that feels like guns or drugs or a knife, he can do a full-blown search. So he cannot manipulate the thing that he feels. He can't move it with his fingers, but if he touches it and it feels like a revolver, he touches it, it feels like a syringe, he can then do a full-blown search to search your entire body, to search you for weapons. And anything that he finds, whether it's guns, drugs, knife, evidence of any other type of crime, would come in against you at trial. The thing has to feel exactly like a gun or drugs or a knife or some type of weapon or paraphernalia. So they can't do any type of manipulating to the outside of your clothes in order to feel if it's a gun or not. If that does happen, what you do is you tell your attorney, look, he was moving it around. He was feeling on it from the outside of my clothes. They are explicitly prohibited from doing that. If the officer finds a weapon or drugs, he can then do a full-blown search, meaning he can go all out and search your entire body. And then what is the wingspan doctrine, which I mentioned previously? If the officer doesn't remove you from the vehicle and he has a reasonable belief that you could be armed and dangerous, he can search anything within your wingspan. Wingspan, think of it like that. When the officer has reasonable articulable suspicion that the person may be armed and dangerous, they can search anything that is in the reach of the person when they are still in the car. This does apply to the center console, the glove compartment, and under the seat. This does not apply to the trunk, and this does not apply when the person is outside of the car. So if they're outside of the car, this does not apply to them. So what should you do if you're pulled over for RAS of a traffic violation? Number one, you're going to ask, why did you stop me? No need to ask if you're free to leave. When you're stopped in a vehicle, you're not free to leave. Provide your license and registration and proof of insurance if requested. If you need to reach into your glove compartment, ask permission to reach into your glove compartment. And that's a safety thing. That's not a law thing. That's just me telling you that because that does protect your safety. Do not get out the car unless the officer tells you to do so. That's also something where I'm telling you to protect your safety. When people get out of the car, they put the officer on high alert. The officer will sometimes draw their weapons. They might tase. You do not want to get out of your car unless the officer tells you to do so. Do not argue with the officer about why he pulled you over. Arguments are for court. So the officer can say, hey, I pulled you over because you had a busted taillight. And you can say, I just went to the shop and got that taillight fixed. I know it's not busted. And that's it. Don't have an argument with the police officer because you're supposed to prove your case to the judge. You're not supposed to prove your case to the police officer. They don't make the ultimate finding of whether or not you're guilty. And they're already there. They're already processing you. You're not going to get out of it by arguing with them. In fact, you're probably just going to escalate the situation further. So it's better to not argue with the officer if he's incorrect or wrong. You can prove that he's wrong on the day of the court date. Now, the thing I said about the taillight, a great example of that is the officer says you have a broken taillight. He issues you the citation for the broken taillight. He goes on about his business. You get out your car and then you take a picture of your taillight to show that your taillight wasn't broken on that day, right? And there you go. You prove your case in court. There's no point in arguing with the officer. Do not answer any questions. So officers are going to do things like ask you where you're going, where you're coming from. These questions seem pretty innocuous, right? They seem pretty harmless, but they're actually not. A lot of the times police officers exploit traffic stops to try to make drug interdiction charges. So what they're trying to do is charge people for guns and drugs, and they're trying to get a way to search your vehicle. They're trying to form the probable cause to search your vehicle and do a full-blown search, right? So when when you're traveling down the I-95 corridor and say you're stopped on the Eastern Shore and you're from out of town, the officer might ask you, where are you going? Where are you coming from? And you might say, hey, I'm coming from New York, I'm going to Florida. To you, that might seem like a really innocent thing to say, but to the officer, they're gonna say, well, that raised my suspicion that there was drugs in the car because people use the I-95 corridor to bring drugs from New York to Florida. So you're not gonna know what that officer is gonna think is suspicious versus what they're not gonna think is suspicious. So it's better just not to answer any of their questions. Literally, don't answer their questions. Just say, here's my license and here's my registration. Where are you going today? How are you doing today? I'm sorry, I prefer not to speak unless I have my lawyer present. Thank you. And then keep it pushing. I always tell the officers that I would prefer to have a lawyer present before I speak to the police. And you can be kind, you don't need to be rude. Provide your license, provide your registration, wait for them to issue the citation, and go on about your business. Okay, so that is what to do when you're dealing with that type of interaction. Do not consent to a search of your vehicle. A lot of the times, it is at the end of the traffic stop when the officer has already determined that your license and registration are straight. They're issuing you the citation or the warning for the thing that caused them to pull you over in the first place. And then they'll say, hey, while I'm here, would you mind if I search your car just to see if you have any guns and drugs? Never, ever give them consent to search your car. As I said before, if they have to ask, it means that they can't do it. An officer will never ask to do something that they're legally allowed to do. But once you give them consent, it then becomes legal for them to search, and anything that they find can be used against you. Even if you don't think you have anything in your car or have anything in on your person, never give the officer the opportunity to search you or search your vehicle. You don't know what someone else had in your car. You don't know what type of officer you're dealing with that day. Do not prolong your interaction with the police. Never ever consent to a search of your person or your vehicle. All right, so the third type of interaction that you have with police that does not require them to have a warrant is probable cause that a crime has been committed right in front of the officer. So in order for an officer to arrest a civilian or search a civilian that he does not suspect is armed and dangerous, so remember, if he wants to search you because he stopped you for a traffic infraction or for jaywalking, whatever the case may be, he has to believe that you're armed and dangerous in order to pat you down, right? However, if he has probable cause, he does not have to believe that you're armed and dangerous in order to search you. And he also doesn't have to have reasonable articulable suspicion. He has probable cause, and so he can arrest you, okay? You can be arrested and you can be searched. Let's dive into that. So what is probable cause to arrest? Probable cause for arrest exists when facts and circumstances within the police officer's knowledge would lead a reasonable person to believe that the suspect has committed, is committing, or is about to commit a crime. Probable cause must come from specific facts and circumstances rather than simply from the officer's hunch or suspicion. So remember before, it was reasonable, articulable suspicion, just a suspicion alone, but there has to be more than that. There has to be facts and circumstances. So it has to be more than just people casing the joint. Maybe you have to see them coming out of the place after it's dark and after hours, holding a sack of burglar's tools and bringing a bunch of bags of money outside of the store late at night with them. Then you would have probable cause to believe that a crime is being committed, a burglary is being committed. So examples of probable cause for an officer to conduct a full-blown search or to make an arrest would be if an officer sees a gun in a car, an officer sees drugs in a car, if he sees a big thing of powdered heroin or powdered cocaine in a Ziploc bag sitting right there on the center console, then the officer can effectuate a search and an arrest. And the officer sees an assault occur. That's another example of the officer witnessing in their presence probable cause that a crime is being committed, has been committed, or is about to be committed. What is probable cause to search? Probable cause to search is when the officer has a reasonable grounds to believe that evidence of the crime is committed, that the officer has a reasonable grounds to believe that evidence of the crime committed is to be found in the place to be searched. So, for example, if the officer has probable cause to believe that you have marijuana in your car and you live in a state where marijuana is illegal, say he sees marijuana sprinkles all over the car, right? The car smells like the odor of marijuana. Maybe he has found a baggie of marijuana on you during a plain field pat down. Well, now he has the reasonable belief that there would be more marijuana in the car, and he can conduct a full-blown search of the car and a full-blown search of your person. Usually, a search requires a warrant, except when the evidence of the crime is in plain view, in plain field, or a search incident to arrest. Now, we have already talked about plain field. Plain field is when the officer is patting you down because he believes that you could be armed and dangerous, and he plainly feels something that could be contraband, like some type of drugs or a gun or a knife or something like that, right? Plain view and search incident to arrest we'll examine now. So what is plain view? If plain view is when the contraband is out in the open where the officer can see. So the officer pulls you over for that busted taillight. He looks over and there's a bag of heroin. Now he can search the entire vehicle for evidence of the crime of the possession of this large bag of heroin, right? Maybe possession with intent to distribute, maybe drug trafficking, right? The officer has to legally be in the place in order to see the contraband and for it to be in plain view. So if an officer pulls you over for a busted taillight, asks for the license and registration, but has no reasonable articulable suspicion that you could be armed and dangerous, you're just a regular person, you're just going about your day, you haven't done anything. They ask you to get out of the car for officer safety, even though they haven't articulated any dangerousness, and then they just get in your car and start searching. That would be illegal, and that evidence would not come in against you at trial, right? An example of plain view is a bag of heroin on the passenger seat, a gun in the lap of the driver, and a bloody knife on the center console. All of these would be reasons that the officer would be able to conduct a full-blown search. What is search incident to arrest? This is another exception to the requirement that an officer has a warrant in order to conduct a full-blown search. The officer already has probable cause to arrest you. Say he saw you beat somebody up, and he searches you right before or right after he arrests you. So it's incident or contemporaneous to the arrest. And he can also search areas that were within your immediate control right before or right after they arrest you, okay? So they've already got probable cause, they're already gonna arrest you, and now they can search, if you're in the vehicle when they're effectuating the arrest, they can search the things that are within your immediate control, but not if you're already outside of the vehicle. They can only search you, and they can conduct a full-blown search. They don't have to limit themselves to the plain field doctrine. So what to do if you're arrested or searched for probable cause? Nothing. You don't do anything at this point. If you're being arrested and you're being searched for probable cause and you haven't given consent for anything, you don't make any statements, you do not consent to a search, you ask for a lawyer, and you wait for your day in court. So many clients ruin their cases by the things that they say as they're being arrested. Oh man, I didn't know you were gonna find that. Look, I have a drug problem. Now you're admitting that you had knowledge of the guns or the drugs or whatever in your car. And whereas you might have been able to say, look, I let someone else use this car and someone else put drugs in there. So never ever make any statements as you're being arrested, okay? Do not argue with the police officer. You're wasting your time. They're not going to unarrest you. They're not going to unsearch you. They're not going to forget about the guns and the drugs and the things that they found. They're not going to forget about the traffic ticket if you haven't even gotten that far and all you're dealing with is a traffic citation. They're not going to forget about that. They're going to give you a citation. They're going to give you a warning. There's no getting out of that. So there's no point in trying to argue your case to the police officer. Wait for your day in court. Okay, so now let's look at what not to do when you're stopped by the police and also what to do when you're stopped by the police. So here's a good example of what not to do. This person has been pulled over and the officer is asking for proof of insurance.
And it is not a crime for me to travel without a license?
Proof of insurance, sir.
So again, they talk about this whole traveling without a license and stuff like that. None of that stuff is based in law. The UCC does not apply to motor vehicle laws. Even if you believe that you're right about the law, you don't want to argue the law with a police officer. He's not the judge. So just provide your license and registration. Of course, if they ask to search your vehicle, say no. You know, that's different. But when it comes to providing your license and registration and your insurance, you have to do that upon request. You don't have a choice.
What you may have,
I'm giving you a lawful order.
what you may have, what you may have is the opportunity.
So at this point, he's failing to comply with the lawful order. The officer cannot identify him because he won't provide his license and proof of insurance. Now the officer has the probable cause to effectuate an arrest. So even these crimes or traffic infractions that only require a citation, an officer is then allowed to make a forceful arrest if they can't identify you in order to give you the citation. They can actually physically remove you from your vehicle in order to place you under arrest, bring you down to the police station, and identify who you are in order to charge you.
It's a whoa. This is assault.
Every time I see this. So don't let that be you. Do not be the person who gets their windows smashed out because you want to talk about your sovereign citizenship or you don't have your license. It's better to just say, look, I don't have my license. Here's my contact information. This is my name. This is my address. This is who I am, such and such and such, and then go on about your business, because you'll likely just get a citation for driving without your license or failing to present your license to the officer. You elevated or escalated into an arrest if you start to become belligerent and do this type of, sovereign citizen type of stuff. Like, that's just how that happens. And it's really unfortunate. I hate to see it happen, but that's what happens when you do not act appropriately during a traffic stop, okay?
Okay. The reason I pulled you, you can't have white light emitting back.
What do you mean?
Your tag lights, they're supposed to illuminate your tag. Those two white lights, all they're doing is shooting straight back. You can't have any white light limiting them back. So then that also doesn't illuminate your tag. And on top of that, you got a border around your tag that blocks the county that you live in. You can't have that on your tag.
Are you talking about the one that the car dealership pulls up, the black one?
That silver one that goes around your tag? Yeah, you can't have that. You got your license, brother?
Of course.
Vehicle registered to you?
Of course.
So, and you got your registration for me? You may ever roll down that other window for me?
So far, everything is above ground, above board, even though I have some suspicions about him talking about the light not illuminating the tag. I'm pretty sure he can probably see the tag. He's saying the light is shooting straight back instead of down onto the tag. Some of his officers nitpicking, he just wanted to pull this guy over. But be that as it may, you have to have the lights illuminating the tag, and the county looks like it has to be seen. And if something is blocking that, that would be a valid reason to pull him over. So now you see that the civilian is doing everything correctly. The civilian is a lawyer, right? So let's, drive like you're a lawyer. The civilian is doing everything correctly. He has his license. He has his registration. He asked the officer why he's being pulled over. He discussed it with him, but he's not arguing it with him. And now he's about to provide his license and registration.
There you go.
Now, me personally, I would I would tell them I need to get my registration out of my glove compartment. Do you mind if I reach into my glove compartment? Because unfortunately, he looks like he's white or Hispanic, but if you're black, sometimes, you might be subject to some heightened violence. So myself, I always say, do you mind if I reach into my glove compartment? Okay. He's handed over his registration. Okay.
Where's home?
Now, he just asked him, where are you headed to and where's home? This is none of this officer's business, and it's a major problem for me, because sometimes they use these type of questions to form probable cause to search. Like, where are you headed to? Oh, I'm going on a trip out of town. Then they'll say, usually people traveling out of town have drugs on them, so I became suspicious, So I always say, you have a Fifth Amendment right against self-incrimination. You are in the custody of the officer. You're being detained. You're not free to leave during a traffic stop. And if the officer starts asking you questions, then they have to read you your Miranda rights and tell you about your right to have an attorney, but they never do that, especially not during a traffic stop. So you just say, if an officer is asking you questions outside of license and registration, please just say, I invoke my right to the Fifth Amendment and I prefer to speak with an attorney. Here's my license and registration, and wait for them to run your information and issue you the citation, right? He doesn't need to know where you're going. He doesn't need to know where you're coming from. He doesn't need to know where you live. That's none of his business. It is not polite conversation. It's actually interrogation. Do not speak to the police officer, which I'm going to make another video about, but just so you know.
University, Pier Drive.
How long you been in Orlando?
None of his business.
Huh?
I work here at St. Augie's or something.
Okay, your address just still says St. Pete on your license.
I need to update it my tag.
Okay. Are you concealed weapons holder? Any weapons in the vehicle I need to be aware of? No, nothing illegal in the car? Alright, so after I'm done, if I ask to search the vehicle to verify what you're saying is true, you don't mind?
I do mind, but...
Okay, so as you see there, he just asked, there was nothing in the vehicle, nothing illegal in the vehicle. And he was trying to make it seem like that was just like a standard question. That is not a standard question. That's interrogation. He's trying to get a reason to get into your vehicle. I always say no. I don't care what's in your car. Say no. You don't have anything in your vehicle. But the other thing that you can say is, I don't want to speak to you. I invoke my right to the Fifth Amendment, and I want to have my Fifth and Sixth Amendment right, and I want to have my attorney present. I will not speak to you without my attorney present. Sometimes that will escalate things, just so you know. But I always say, I don't speak to officers without my attorney present. I'm not speaking to you. Please run my license and registration. And leave it at that. Because what they're trying to do is find a way to get into your car. But if they do ask you, do you have any weapons, any guns, any things like that in the car, it's always okay to say no, or to say, I don't wish to speak to you. Either one of those things are okay to say. The next thing he asked him is, can I search the vehicle? And again, if an officer is asking you whether or not he can search the vehicle, it means that he can't search the vehicle. He doesn't have the right to do it. So you always say no. And so this gentleman said, I prefer that you not, which means that he doesn't want him to search his vehicle. And the officer should not be able to go any further from there. He just told him that I'm a lawyer, so I prefer that you not search my vehicle.
Okay. So you know what consent is? That's what I'm asking.
Yeah.
So you have nothing in the vehicle?
I have absolutely nothing in the vehicle.
Okay. And you don't mind confirming that by allowing us to look and make sure there's nothing in the vehicle? As you can imagine, we hear no all the time as they have nothing and we find stuff.
And you hear what he just said. We know, as you know, all the time, people say they have nothing and we find stuff. And that is true, because people think that they're being slick by saying, okay, yeah, you can search because I don't have anything. And then they think the officer will give up and not search. They're going to search, and then they're going to find whatever you have. It's always better to say, no, I do not consent to you searching my vehicle. No, I do not consent. And this officer is trying to convince him, persuade him into changing his mind, and he's doing the right thing, the civilian, by deciding that he's not going to consent to him searching his vehicle.
Okay. Cool. Just hang tight, brother, okay?
So now they're going to run his license and his registration. It's going to come back good. We're going to skip through all that.
All right, Nicholas. So one, you got to get that fixed, those white lights in the back. Okay? You keep getting pulled like that, you're going to get tickets nonstop.
I'll get it.
You understand that? That border? Take that border off. Understand that? Fix that address. Just giving you a warning for it.
So there he walked away with just a warning. Now the regular everyday, not saying, hey, I'm a lawyer and I'm not going to let you search me. Sometimes an officer will escalate that situation. Hold fast, If they decide that they are going to force it and they're going to search anyway, at least you did not give consent, right? And so I think that those are two different examples of what not to do when you're stopped. And another thing that is really important to know is that once you've been arrested, right, then the officer can search incident to arrest. So it's really good to try to avoid not being arrested. Always have your license, always have your registration. And if you don't have those things, then it's better not to argue with the officer. You might be able to just get off with a citation. If you can't get off with a citation and they're gonna arrest you anyway, do not fight them, because then you're gonna get a resisting arrest charge. You're gonna get a fleeing and eluding charge. And you don't want that. Assault on a police officer is usually an enhanced penalty. Sometimes it carries mandatory minimums with it. You don't want that in your life, right? So these are three good examples of what to do when you're pulled over and what not to do when you're pulled over. So let's just recap before I get out of here. So if an officer stops you while you're walking on the street, you're not operating a motor vehicle, you're not doing anything wrong, the first thing you want to ask him is, why did you stop me? And they can say, oh, I just want to talk to you. I just want to see how it's going today, man. And then you say, am I free to leave? And they'll tell you that you are, and then you should leave. Do not engage any further with the officer. Leave the situation, get away from them right away, okay? Because they're allowed to do that, so it's not illegal for them to ask you. But the minute that you submit to their authority, then you run the risk of them searching you. You run the risk of you getting charges. It's better to just get away from an officer. Number two, if you're inside of a vehicle and you're stopped for a traffic infraction, ask the officer for their name, ask them for their badge number, ask them why they stopped you. They are entitled to tell you why they stopped you and provide your license and your registration. There is no getting out of having to provide your license and registration. And in fact, failing to do so can lead to you getting your windows busted out. It can lead to you going to jail. It can lead to all types of bad things. If an officer asks you for permission to search either your person or your vehicle, they don't have the right to search your person or your vehicle if they have to ask permission. Because if they had the right to do it, they would just do it. They would say, hey, get out of the car from me. I'm about to search your vehicle. And there's nothing you can do about it. But if they're asking for permission, that means they don't have the right to do it. And so you should never, ever give an officer permission to search your vehicle. If an officer is asking you questions other than, what's your, can you give me your license and your registration, and you hand that over. But if they're asking you questions about where you're going, where you're coming from, where you work, what you do for a living, how much money you have in the car, do you have any weapons, say that I invoke my right under the 5th and 6th Amendment not to speak to you, and I do not speak to police officers without my attorney present, okay? They cannot force you to make statements. They cannot force you to give consent. They can force themselves onto you and search you. They can force themselves into the vehicle and search the vehicle, but you should never give them the ammunition to be able to make the charges stick, okay? So you never, ever want to do that. And invoking your rights under the 5th and 6th Amendment to remain silent and your right to an attorney does not give them probable cause to search you. It cannot form a basis for you to be suspicious. So that's basically it. Those are my tips on what to do when you're pulled over by the police and what not to do when you're pulled over by the police. This is, Fourth Amendment law is very intense, right? It has a lot of details that even seasoned lawyers will sometimes have difficulty with. It's something that requires a lot of research. It's ever changing. New laws happen all the time. So if you guys have any questions about particular things, I can answer them in the comment section below. And I may even make a video based on what your questions are. You guys have a good day, and I'll see you later. Bye.